Hi, I'm Laura Cooper. I'm a class action litigator at Fasken, where I chair our firm-wide litigation and dispute resolution group. I'm pleased to introduce our new video series, Anatomy of a Class Action. Our 5 videos will showcase some of Fasken's terrific class action litigators from across the country. My colleagues will explain the procedural path of a class action in Canada and will highlight some of the differences from and similarities to class actions in the U.S. We hope you enjoy our series, and of course, if you have any questions, please do reach out to any of us.
Canada's system for navigating multi-jurisdictional class actions is a maze. It's just not a business-friendly model. Multi-jurisdictional class actions are complex to navigate in Canada.
But most class actions in Canada have a multi-jurisdictional or national component. The absence of a federal court system of general jurisdiction means that defendants can face overlapping actions in multiple Canadian jurisdictions or national classes with uncertain effect.
For over 50 years, the U.S. federal court has had a procedure for centralizing and consolidating multi-district litigation. So we always get the question, why doesn't Canada?
The answer is Canada's federal constitutional structure and the lack of guidance from the Supreme Court of Canada. The Supreme Court of Canada hasn't addressed in detail how courts are to deal with multi-jurisdictional class actions.
While we wait for the Supreme Court to weigh in on these issues, there are existing complicated processes for managing multi-jurisdictional class actions. This is further complicated by judicial trends, which right now are toward tolerating overlapping actions in more than one province, at least through certification.
To act strategically, defendants really need experienced counsel with a national presence. It's that national expertise that really matters. Having a team with on-the-ground expertise across Canadian jurisdictions that can look at the problem and design the best approach for moving ahead.
We might push forward in a particular jurisdiction, for example, where we think we have a good chance at setting the right precedent. We often have to be very creative, both legally and in negotiations, because so much of multi-jurisdictional management is voluntary and cooperative.
Until the Supreme Court steps in and defines the rules for overlapping class actions in Canada, it will continue to be messy and uncertain. But if you know the legal landscape, that creates strategic opportunities.